Okay, good afternoon, ladies and gentlemen. The Board of Zoning Appeals is now in session. All right, we'll get started. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. Would ask that this time if you'd either silence or turn off your cell phones. Candidly, you probably don't have much reception in this room anyway. So the procedure would be to introduce the case record as the Codes Department has it on the wall here by means of a PowerPoint presentation. We'll present site plans, photographs, and maps of the properties involved in today's cases, as well as any letters that we've received in support or opposition to a case. At the conclusion of my presentation, the applicant will come first and present their case to the board along with any persons in support. After the applicant goes, if there is opposition present, the board will hear from those parties opposed to a case. After the opposition presents their side, the applicant will have a period for rebuttal. The board in their rules provides applicants in cases without opposition 10 minutes to present their case to the board. In cases with opposition, each side of a case, both the applicant and opposition, will have 15 minutes in total to speak. Again, if you have multiple speakers, please divide your time before coming up. All section numbers I refer to today come directly from Title 17 of the Metro Code of Law that applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted January 1st, 1998, and applies to the entire jurisdiction of metro government. And I'll introduce and make a part of the record that zoning code, a copy of which is at my table behind me, and I'll dispense from reading individual sections unless the applicant requests that I read those sections. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address the board, please come forward at the table here in front of me. Hit the speak button on your table. Your microphone will turn red like mine is here. Present your testimony to the board. The board will go through all cases set for public hearing today, and after each case, the board will discuss and vote on that case. The code requires that 4 members of our 7-member board be present. To constitute a quorum, I have 4 members present today. At this time, you need all 4 votes for your case to be granted. In the event that you do not receive 4 votes today, your case is automatically rescheduled for the next available public hearing cycle, which I believe tentatively would be the first meeting in April 4th. In the event that your case is heard by more than 4 members and you fail to receive 4 votes today, your case will stay on our agenda for the next 30 days. The board members that participated in that case are allowed to change their votes. Board members who did not hear your case must review the record and to become eligible to participate. But if after 30 days you fail to get that 4th vote, your case is deemed denied by operation of law. If you're an applicant or an aggrieved property owner, you may request a rehearing within 60 days of today's public hearing. Further, you may also appeal the board's decision to Chancery or Circuit Court within that same 60-day period. But after 60 days, the board's decision is final, and no further action may be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied. This proceeding today is just one step in that process, so follow back up with the Codes Department beginning on Monday to finish processing your permit. Mr. Chairman, I submit that all cases were filed in proper order. All applicants were notified by certified mail as required by the code, and a legal ad was published in the Tennessean. Before we begin with preliminary announcements, the board does allow elected officials, if present, to address the board. Do we have any elected officials present? Mr. Chairman, I see none. First preliminary announcement, on our agenda today, case 20 at the bottom of page 2, that case has been deferred by the applicant until April the 18th. We'll renotice that case. That's the only preliminary announcement I have. Before we get into today's business, we do have 2 cases that are tied up on votes. Case 11 and 12 on 1623 and 1621 Cahal Avenue. The members present hearing this case. Mr. Harper, you're not eligible to participate in this one.
I don't know why I got out of bed.
Every day you get out of bed's a good day. Mr. Whitson, Mr. Ewing, Ms. Jones all voted in the affirmative. Mr. Whitson, you're the only one of those 3 here. Do you wish to change your vote in any case? All right, Mr. Whitson does not change his vote. Mr. King and Mr. Taylor voted against the request. Do you guys wish to change your vote this time? None. This vote remains tied on a vote of 3 and 2. Both cases will remain on our agenda for the next meeting, March the 7th, for its final appearance before this board. The board does have a consent agenda, and prior to today's meeting, a board member, in this case the chairman, Mr. Whitson, reviews each case, and if in their opinion the applicant has met the criteria for the application they've requested and they feel that testimony would not alter the material facts, Mr. Whitson recommends these following cases that I call to be on the consent agenda. If there's anyone here in opposition to the following cases, please raise your hand and let me see you, and we'll hear its case in regular order. The first case recommended for the consent agenda is case 2013-17, Miss Servey at 5629 Kristen Lane. Is there anyone here in opposition to case 17? I hope I pronounced your name correctly, ma'am. Severy, I apologize. My name is butchered frequently, too, with Hargis. So, anyone here in opposition to this case? Mr. Chairman, seeing none. The exceptional shallowness of this lot necessitates a need for a variance in this case. The next case recommended for consent, case 2013-18, Fraser, help me with your last name. Chaffel, thank you. 2300 Sterling Road, requesting a variance in the side street setback in RS10 to construct an addition with an attached garage. Is there anyone here in opposition to this case? Mr. Chairman, seeing none, the narrowness of the lot necessitates a need for variance in case 18. With that, Mr. Whitson recommends that case for the consent agenda. Case 2013-19, Mr. Chris Choate and Ralph White, the owner at 1049 Chickamauga Avenue, requesting variance in landscaping and fencing. Height is to be restricted. This case actually was approved by the board in 2008. The 2-year time limit has ran. The proposal is identical in all respects to the proposal previously approved. Mr. Whitson recommends us to reapprove and reauthorize that construction for another 2-year period. And then finally, the last case recommended for consent, case 2013-21, Lurson Construction, 4305B Dakota Avenue, requesting a variance in rear and side setbacks to construct a detached garage. Is there anyone here in opposition to case 21?
Joey, I actually have a question on that.
Yes, sir.
Somebody triggered a thought. Is that a private sewer easement or a public sewer easement?
That I don't know. It's a private easement.
Private. Okay, I think we need to hear that.
Okay. With that, we will hear case 21. We do have a motion by Mr. Whitson. Do I have a second on cases 17, 18, 19, and 20?
Second.
All right, Mr. Harper seconds.
Okay, so we have a motion, we have a second. All in favor? Aye. Any opposed? Passes.
You're here for cases 17, 18, 19, and 20. You are free to go. Your cases have been approved, and we'll hear the final case on today's agenda.
I have a quick question about case 20 that deferred.
Yes, sir.
Were they changing something, or
No, they
was there
were.
opposition, or?
They were. No, there was. There is really a timing issue with some financing that did not come through in the exact time, so they need a little more time to discuss. And we'll hear case 21. Mr. Lurson, if you'll come forward, please. Let me show the board the photographs for the slide today, and the record will reflect Mr. Ewing has joined us. We have 5 members present. No other parties present here. You do have support. Yeah. Would you like to come up to the board and address them if you wish? Let me go through our case first. The subject property is located on the south margin of Dakota between 44th and 43rd Avenues North. This is a grandfathered duplex situation. As you'll notice, the RS 7.5 zoning. The zoning code allows grandfathered duplexes to reconstruct within a 2-year period of its destruction and also separate those units, whereas normally inside the urban zoning overlay they have to be adjoined. This part of the code does allow them to separate these units. This is the former duplex, and you see in the aerial photograph, and the former garage located on the site prior at the rear of the property. And
actually, Joey, that rear unit was a third apartment.
Third dwelling, I'm sorry. Well, thank you.
Triplex, actually.
Excellent. These are important things to know. Thank you. So we had 3 structures. We're down to 2. And then the request is to construct the detached garages at the rear of each structure here. This line that you see separating the 2 is not a true property line. That is a limited common element line that deals with ownership and use between the owners. But essentially what you have is one piece of property. Detached garages are permitted up to 700 square feet to be located and receive setback breaks off the rear and side property lines to 3 feet and to 10 feet off the alley. So one of these 2 is fine. The appeal on the second one, second structure has to be 20 feet off the property line, off the rear. This is the right-hand side, I guess, facing the units from Dakota looking south. And this would be the structure at the back of this property that needs the appeal. This is the left-hand side is the first unit of this duplex, and then the adjoining properties on either side. Again, we issued permits on the first garage behind this unit on the left-hand side. If you're looking at it from Dakota, it conforms to the setbacks. The request is to construct an identical structure beside it, behind this residence. And then again, as you'll note, many of the detached garages in this area are very similar in its location. Sort of the pattern out here. 20, you only get the break on one of the 2 structures. If you build two separate structures, both under 700 square feet, only one can get the setback breaks. The second one has to meet full setback. Our zoning code just requires that you only get one break on these detached structures.
Even if it's a duplex?
Even if it's duplex.
Okay. Could you kind of briefly tell us about how the law has changed that now allows these unattached duplexes for grandfathering?
This one, actually, this amendment came through at the same time that the duplex definition was amended. Duplexes forever, basically, were essentially 2 units in one structure. Most folks recognize those. The zoning code allowed, with amendment, I believe in 2008 or 9, to allow those outside the urban zoning overlay, which is essentially the old city of Nashville, to separate those units and be separate. This is an area that would have been part of the old city, so they have to still be in one structure. The exception to that example is a grandfathered duplex in a single-family zoning. They are allowed to separate those to make them look like 2 separate single-family dwellings. So from the street, it looks like there are 2 houses on 2 lots, but it's essentially one duplex on.
So without being attached and without some kind of joiner umbilical cord thing that developers like to kind of say.
Well, I can tell you, I can speak as somebody that does it. Developers do not like the umbilical cord. They would love for it to go away. This is an example that does allow such a removal. As you'll note, the parcels where my cursor is showing here, these at the time were connected, and you'll notice there's a connection between the 2 units here. But that amendment, more recent amendment, allowed that umbilical cord to be severed, and you can separate the units.
And just when I say umbilical cord, it's just basically some sort of structure that basically touches both houses, and there's usually nothing
For
in
us,
that structure.
it has to be some sort of, it can't be a false walls. I mean, it does have to be usable, functional area, storage rooms. A lot of people use them as storage spaces for each side of the unit, or garages. We've seen that done, but it just couldn't be dead space, just non-framed up area.
They would have to have a variance of some sort if they had attached those garages, because they would be more than
Yes.
700 square feet.
Yeah, if the garages were combined, that one garage with 2 bays would be over 700 square feet and would have to meet full compliance.
So they would have to, okay.
So they could separate them in
And then what would
in
be
one.
involved in separating that property?
For us, the separation, the subdivision of that property could not occur. Its configuration as it sits today as being one lot with a duplex on it, they'd have to go through a subdivision process of subdividing the property, but they would lose their ability to duplex it. Ultimately, at the end of the day, you end up with the same product on the ground. It's just you'd have to separate it first and then build it. You couldn't build it and then separate it.
If the lots were separated, then they wouldn't be here. They could have the 2 10-foot setback garages.
Yeah, it's sort of a timing issue. They would basically be giving up their ability to do a duplex subdividing it, no guarantees on a subdivision that it gets approved, and then if the subdivision were approved, they could build single-family residence.
And what would be the variance if they were connected again?
20 feet off the back would be the required setback as listed.
So that
on
they,
it.
in theory, they could connect them and ask for a 10-foot variance.
Well, if they were true separate properties,
But they're not separate. I'm saying in this case.
yeah. In this case, obviously one structure is constructed, and most of these we see are generally detached because you have this private element aspect of ownership going on. But if you attached it, then the structure that's already been constructed here is now in violation.
That's the one at
Yeah, this,
4305A?
yes,
It's constructed?
This structure in the upper left does conform to the code as it's written today. But if they were attached to this garage and offset it back to 20 feet, it would cause this garage to be in violation of the code because it's all one structure.
But they could ask for a variance for that.
They
though.
could.
Just like, okay.
And I know we're asking a lot of questions
Yeah.
before we
No, that's fine.
get to the appellant, but tell me how difficult would the process be to separate those two lots? You said you all wouldn't do, I mean, do you go to planning commission? Who do you go to?
The planning commission is the entity that would do that. I can't really speak to their subregs or what they would look at. I'm just more ignorance than those regs have changed since my involvement in them on a day-to-day basis. I think they look for similar lot sizes to do that. The issue in this, again, would be a use, abandoning the use, splitting it, and then coming back to reconstruct single families. It's just,
Okay.
No, but thank you, Joey. I think this was very helpful for us and
These are-
even the people watching at home to kind of.
You guys and folks watching home have seen similar situations to this.
And the appellants are getting to watch this whole discussion
Yes.
and even take part in it.
With that, I'll turn it over to you guys and let you guys present your testimony.
Okay. My name's Paul Larson, and thanks for hearing us today. Joey, did you have that one picture that showed where the existing sewer line is?
And sir, could I get you to spell your name for our court
It's
reporter?
Luehrsen. And what
Thank
we
you.
did when we, and if you don't find it, Joe, I've got a copy of it here too.
We have a copy of it.
Oh, do you? Oh, okay. Yeah, when we went to lay out the garage, like I said, there were 3 units there originally, the 2 front units and the back units. So from our development costs, we're trying to use the existing sewers, taps that are there, and there are 2 separate sewer taps existing on the property. The back unit and the right unit were using the same sewer tap, and the left unit had its own sewer tap. So our goal is to use a sewer tap. When we went to lay out the second garage, we found out that the existing sewer line would run right through the middle of where the second garage would go. So I happened to be at Codes and was talking to Joey about the fact that we have this existing sewer line that we want to use that's setting there, and wondered what options we had. And then Joey's comment to us was, well, you could apply for hardship variance. We would have to dig up and abandon that sewer and put in a whole different one if we, had to put the garage farther back. So that's kind of the basis for our appeal.
So was the sewer line in place when you bought the property?
Yeah, all the sewer lines.
And that's how
were.
it was serving, this line was serving the duplex?
We're serving one half of the duplex and the one, we're serving
But
2
there
of
are
the
2
units.
taps, but it was,
Yeah, it was serving 2 of the houses, and then the other line that we're using serves the first house.
and
Go ahead.
And just to play devil's advocate, what would happen, would anything change if you relocated part of that line? Would you have to resize it or retap? I mean, does it meet, it's usable as it is, but if you changed it, would it?
Well, I guess the main issue would be it'd be quite an expense to have to abandon that and dig it up and put a whole different line in. We know that the fall line works right now with where the sewer is. We've got the proper fall from the house. The sewers are rather deep in that alley. Because if you look at the grade, it actually falls from the alley to Dakota, so the sewer taps in the alley are pretty deep. So we'd be having to dig, pretty deep trenches to put something new in. So that's kind of, again, why we wanted to use
So
it.
best case scenario, you would be able to, you would have, I guess the best case scenario is you would be able to tie in where it dog legs. You'd have to tie in into
Yeah, right behind
right
the
before it
middle
goes
of
to the
garage.
tap, and then somewhere closer to the house.
Yeah.
Okay.
And I guess the other issue is you couldn't build on top of the sewer line, obviously, so that had something to do with your placement.
Yeah, because then you wouldn't have access to it if you ever had to dig it up or whatever, but you can't build on one anyway. So
It's a private sewer, you can build over it, can't you?
If it's a city, this is
It's a private sewer.
I don't think you can put a,
Not that I'm aware of.
Private line. Sewer lines run under houses.
well, if you,
That's a garage.
I've never,
Unless this plan is incorrect.
well,
Doesn't look like you're building over it anyway, so what's the?
I guess,
This is the preferred.
I guess as a builder from, having doing this for, and selling something to a homeowner and wanting to make sure that you're assuring them, good value and not any maintenance or issues down the road, I just wouldn't want to put a garage over an existing sewer line. I mean, just from a practical point of view, just if the owner ever had some issues or needed maintenance or something down the road, you're kind of limiting their options. So I guess just from a practical point of view, that's not something I would, I guess I hadn't considered because I just wouldn't feel that'd be doing much of a favor for a future homeowner.
I mean, you said that when you were laying out this garage, that that's when you kind of realized it was over the sewer line. And so I'm curious to know, did you intend, when you were laying that out, to have a 20-foot setback on that garage?
I think initially when we had done the demolition is when you kind of find out where a lot of the sewer lines and where the water lines run and stuff like that, because you're digging out old footers and stuff like that. So, and when we saw where the water taps were coming off the alley, we felt we had a fairly confident idea of where everything was. So when we came down to codes and I was given the 10-foot setback and the 20-foot setback, I said, well, that's what the code reads and that's how we have to kind of live with it. So, and then when I found out that the sewer line on the one side was totally different, we'd already started the other one, and then we came and we determined where the other sewer line was. Like I said, I had business down at codes anyway, and I happened to be talking to Joey about it and just saying, son of a gun.
What do we do?
Yeah, what do we do? And I said, I'm looking at, quite an impact to, the project and, what are my options? And this is
and I mean,
kind of where we got
it
to where
makes
we were.
sense. I understand it. It makes sense. It looks visually like it makes sense. But, on the plans that I have that look like they're dated the 6th of January, I mean, it shows two identical floor plans with two identical garages, both 10-foot off
Well,
the alley.
actually, Joey asked me to put that together. I just took an old plan that I had and recatted it up for him.
Okay.
He asked me to provide something, so I do all my own design work and plot work and stuff like that. So I just went back and catted something up for him so that he'd have something. So
That's generally submittal. Guys, one thought I had too, if the board members are feeling sort of heartburn over this, would be to grant the variance on the structure that exists, the variance, and then this structure with the sewer line actually complies as it lays today. But both of these structures, from our standpoint, can't sit at 10 feet without an appeal. So if there's a...
Is there a hardship for the existing one, other than the fact that it's there now? Hypothetically.
That's for the applicant.
I guess that's kind of for you guys to
That's why I said
decide, but-
hypothetically. I don't want to suggest that there's but we would need a hardship.
Or I guess you would be saying that the hardship to move the other structure that we are talking about would be such of having to replace that sewer line, it's better to grant it for the one that's there now.
The second one probably does have more of a hardship.
I mean, and Joey, I'm just curious to know, I mean, do you have any just rough estimate guess of how many grandfathered duplexes there are? It seems like that when those rules are written, that this is the type of lot that you just don't think about because it seems like it's reasonably rare. To me, that might be a case. I'm not making the case just yet, but it might be the case for a hardship to say, look, this is just a rare situation. You have two lots that are almost 50 feet each. Well, not almost, they're at 42 and a half feet each. And when the rules were changed and written, they just didn't have this or pie-shaped lots or other shaped lots in mind. Is this a pretty rare occurrence?
I would say in general, yes, this is a rare occurrence. I mean, there are some parts of town that's more common, more frequent. This area out here, there are some grandfather duplexes out there that'll still remain in one structure.
Joey, can you pull up the plan that had the previous structures?
Clearly, what was out there before was quite unusual with the triplex laying out there.
And the back unit on the alley, if you look, there's a little bump out on the bottom there.
Right.
That was the original unit, and then they had added on to that direction of it. And in that case, they had built over the sewer line.
I was going to say,
Yeah.
So where's the other sewer line?
The other sewer line actually is in the perfect spot. It runs almost right on the 40. The two taps are, if you see on the alley there's a shadow. Looks like it's maybe garbage cans or something. A little more to the left there. Yeah, right there. That's where both the taps are.
So they're 3 or 4 feet apart?
Yeah. And I would say they're about 7-8 feet down, probably something like that. Because like I said, the whole property slopes toward Dakota. So the sewer has to be fairly deep in that alley right there to serve all those houses.
Is that common, Joey, for duplex to have two separate taps?
Yeah, it is. And
I guess for metering?
many times for metering. It's not a requirement from us on the new construction. It is a mandatory requirement on the electrical side now. It didn't used to be even for water or electrical, but we do mandate that you separate services for the electricity side. Just from a public safety issue, you know, if the meter's over on one unit and that guy's not home and you're having an issue, you need to be able to shut it all down per unit. Where it's water, you just go out to the thing and turn the key and it shuts everybody down. But I don't know if that was an answer to your question.
So you're developing and building these to sell, correct?
Yes.
Sir, did you want to add anything or get on the record? Just push your button there on your microphone. Give us your name and spell your last name.
My name is Jimmy Morton with Morton Plumbing. The reason I'm here is really just for support and for information if needed. In running the sewers, I suppose we could separate it, but they are deep. It's in West Nashville, so there's rock. It's going to get expensive to do that. One of the options we had talked about was putting a pump in, and that would be a real good option, with the exception of he's going to have to put a whole house generator in. If electricity goes off, you have no sewer, then you have a health hazard. So there was other options, but none of them that we could figure out would be good.
So what's your fear of building over? That's a garage back there you're talking about building over.
Well, like I said, it's again, I always try to look for someone's going to buy it someday. It's home is a huge investment for someone, and it's kind of I look at it as my responsibility to look out for them down the road as much as I can. And if it's my personal home, I don't want to have a structure over a sewer line. Stuff happens. You can't tell 3, 4, 5 years down the road. Something needs to be changed out. The city comes through the alley and changes something out, and you're creating kind of an unknown now for someone down the road that they're going to have to deal with versus, just get a backhoe and go between the garages or behind, be able to have easy access to it. So like I said, I've never really researched building on top of like a sewer line or something like that because I wouldn't, if it was my personal home, that's not the way I would like it to be. So.
Do we even know, can anyone confirm if it's allowed by codes to build over?
I would say, Mr. Harper, I don't know the answer to your question.
But if it were the city sewer line, you couldn't.
No, there's absolutely not even, you couldn't build over it. You couldn't build within 10 feet of it.
Yeah.
But I think it's probably safe to say that there is no shortage of homes in this town that have either a driveway or a garage or something over a sewer line, because there are too many houses and too few options for the sewer line to go on those lots.
I would admit a lot of people have a home and then they bring someone in to build a garage on it. And as far as I know, I don't think there's any permit discovery that you have to provide on, what you're building over, other than, you'd call Tennessee One Call and make sure there's not a water line or a gas line before you would, dig a footer. But I don't think like Tennessee One Call would identify a sewer line. So I would agree there's probably a lot of secondary construction that, other than water and sewer lines, they don't really know.
Joey, can I direct this question to you? Because I'm just struggling to figure out even what the societal good of making it be 20 feet is. Because as I look at this airborne, most of them are at 10 feet or less.
Or zero.
I'm sorry?
Or zero.
Or zero, and so they're all kind of at 10 feet. I'm trying to struggle. I mean, I know the law says 20 feet, but what is the purpose of the law to make it 20 feet? Because if we do make him comply, we're talking about a real cost here, and I'm trying to figure out how mankind's better.
Well, the code subjectively picked 700 square feet as that magic number. I'll just tell you that. They had to pick a number. They picked 700. It used to be 576, so they actually raised it. The idea for that setback was to get the vehicle off the street. So before, if it was under 576, you only had to have 10 feet, which would let you get the car out of the alley. Envisioning, I guess, someone actually getting out of the car and lifting the door, but most folks generally probably have and get it off there. But I guess in principle, we did not want to have people having multiple structures in their backyard all at 10 feet or all at 3 potentially. So that way, that was sort of the reason Sonny would say, all right, we'll give you the break on the first one, but the next one's got to meet full compliance. Even though it's the same size, we're going to make one comply. It was just sort of a policy decision to not allow multiple rear structures to.
But that was predominantly for a single family.
Well, yeah, it takes into account even a shed or a storage building. If we were talking about
but that general rule is applied here because
not commercially.
It's being treated as if it were single family, even though it's a duplex.
Yeah, and that restriction would be both duplex and single.
So that gives
not multifamily. But
that gives us at least the parameters to have a discussion on it, right?
But is it sighting through the alley, or I'm just struggling to figure out.
I would guess either cars backing out of the garage into the alley. I don't know. I mean, the practical nature of it is that, if there were a property line splitting these two things, it's fine. Just because it's a duplex and it can't separate and it's got to be on one lot, it's not okay. And one structure's fine, the other's not. We would like a little text change. Maybe we can apply it in an aggregate situation, but that's
I was just curious.
Well, I'm just going to throw this out with my limited knowledge of the science of plumbing, and the only rule that I really know is that it rolls downhill. So, as I was saying, if the practical solution to, if you were to meet the setbacks, I'm sort of posing this as a question, so bear with me. And you tied in, like I was saying, describing before, if you tied in at the dog leg as it comes off the tap and then somewhere back in the yard to follow the same flow, it appears that about 30 plus feet of the line would be abandoned in about the same amount. 40 feet would have to be installed, and you think the line is about 7 to 8 feet deep at that point, or do you know how deep it is in the alley?
Yeah, it would probably be between 4 and 5. It's deepest at the alley because that's where the elevation's the highest. So as you get closer to the house, right at the house, it's probably going to be about 3 feet. So it's kind of like I said. The issue isn't could something be redone. It's like I said, my hardship is just the line is there, and I would have. significant expense to change to
Right.
redo it.
And we're not allowed to consider cost as the only reason.
I understand.
And I'm trying to determine if it's a topographic issue, in that it's the fact that it's as deep as it is. Because I scooted your footprint back 10 feet, and that's why I was getting the 40 feet.
Yeah.
I just want to make sure I understood all that.
Yeah. We've run cameras up both lines, and they're, like I said, in very good shape. They work. They were clear, and there's no damage to them. So it's kind of that kicking a sleeping dog kind of thing too. But anyway,
Do we have any other questions? If not, I'd say let's close the public hearing and have discussion.
Thank you.
I think it makes sense. I got a couple of thoughts. One is that there are elements of it that feel like, asking for forgiveness instead of permission, which I don't like. But I do think that, and I don't really, frankly, agree with the hardship that's stated, because I think that you can build on a sewer line, especially when 7 feet deep. I don't know that I don't know that I 100% agree with that, but I do think that there is a hardship in that it is an exception to the rule because of the type of lot it is, and I'm not sure how that will be worded, but I do think that. And I think that if it's forced to go 20 feet and the other one 10, based on what we've heard in terms of the history of it and how it works, I think that every neighbor that goes down that alley is going to think that's goofy. Why is it that way? It shouldn't be that way. It doesn't pass the smell test of common sense, And so, to me, if the lot were separated, which I think it could be, by every person that looks at it, I think, we'll assume it is separated because of just the two houses and the two garages. If it were separated, a 10-foot setback would be a no-brainer. It wouldn't even have to come to us. And so I'm willing to figure out a way.
Interestingly
to make it
enough,
happen.
David, actually the last sentence in their hardship statement, the hardship claim would be having to move the sewer line, and I think that actually, I tend to feel that is the hardship, that because of the topographic nature, not so much that we can't build on a hill, but just because of the way things line up underground. But and I always like to look at the other options. It's like, is this a hardship, or are you taking the easy way out? And interestingly enough, if the property were divided into two parcels, then you have a whole easement issue you have to get into with the line, because the line is actually on the other half of the property before it doglegs over. I'm not really trying to make the case for them, but it's not exactly a clear-cut issue, but I think in my mind it's sort of a combination of all these issues. It's like, why don't you subdivide them? Well, then it's going to get hairy here, and there's no guarantee that will work. Why don't you move the line? It's not just because of the expense, but it's a significant expense. I mean, if you had an exceptionally hilly site, you could build a retaining wall, but that could be an exceptional expense.
Joey, did we receive any letters of opposition for this particular case?
No, sir.
I do think it's a hardship, and I think all of the options are worse. Making them move the line is expense, and I would say I don't see much reason. Building it over, when there's a problem, you've now got to go tear down your garage or a significant portion of it. And three, I don't think it's going to make the neighborhood any better to move it to 20 feet. So I guess I do see the hardship, and I don't see any real, and I'm sorry, I hate to say it, I don't see any societal good by making them move it to 20 feet. I mean, it's just a quirk of the law. I mean, why? It's as if the law has no real purpose. I mean, so anyway.
Yeah, and I agree that it should be 10, and my only comments on the hardship issue are that I don't want it to necessarily be an overarching precedent for other cases. I think everything is in this nature a case-by-case basis, and so if you all agree it's a hardship, that's fine. for whatever reason, I agree. We all have the same outcome, I think, in mind, or at least the three of us that have spoken on it.
I do think, and I'll address to those with the law degrees in the room, that we have to. I think we have to be careful about saying in our motion and whatnot that if we approve it, that it doesn't seem fair.
No, none of that would be in the motion.
Yeah, and
none of that.
I'm trying to, and you both expressed, I think, my thoughts better than I did, but I think there's a hardship. I was just having a hard time nailing it down to exactly what it was.
I'll play the devil's advocate here. I don't always agree with everything I see on the Planning Commission. They do, but I got to believe that they have some logic in there, or a method to the madness, perhaps might be better to say. And I too don't understand it's okay 10 feet here and it's got to be 20 feet if you're 15 feet over. I don't understand that at all. But I'm not in a position to really question or challenge that, and the developer, I think, has an inherent responsibility to himself to do his due diligence, unfortunately. If that were say something that he couldn't avert, like a city line that he discovered under there, which we had a case on not very long ago. That's a private line, and I think there are other options. I'd be hard-pressed myself to find a hardship on it, so that's my position.
Well, just so nobody thinks I'm throwing rocks, I am a former legislator and I am a lawyer, and I can't tell you the number of laws you run into that just really don't make a heck of a lot of sense. I mean, it's because you're passing huge laws and then you have very individual cases. And so I think the BZA exists for a very good reason. And so I'm throwing rocks at myself. I'm sure I have passed laws that are too broad in nature. And so anyway, I'm not throwing rocks at others. I'm throwing them at myself. But in this case, I don't think it makes a heck of a lot of sense. But anyway, but that wouldn't be my motion.
I guess my question would be, in that that I don't see a true hardship here. Would we be setting a precedent to circumvent that setback rule in other cases?
I think others who have spoken have said that there was a hardship.
I do think that the hardship is that it's the nature of that lot. I mean, and I live on a pie-shaped lot, and I have had to, not this board, I went to the historic zoning board for a permit once, and my point was there are 8 pie-shaped lots out of 800 in this overlay. The overlay wasn't written for the 8 pie-shaped lots. The overlay was written for what I would call a normal or something regular, a rectangular shaped lot. And so I can't say I was 100% successful, and but that was the point, was that I think it was what you were saying too, was that when you make a law like that, you don't always take into account these irregularities, and I think this is one, and I think that's the hardship.
I agree about that, but I don't see even an irregularity in the shape of the lot here.
Well, but I strongly do believe that there is a hardship, because if this were a public easement, we wouldn't let them within 10 feet of this thing. And so if it's, in my mind, if it's good for the goose, it's good for the gander. I mean, if we're going to protect public utility easements, which we do, and with good reason, I don't see any reason to make a private guy go build over it, because, inevitably it's going to end up a big expense to somebody within the next 40 years. So anyway, I am brave enough to make a motion if anybody will listen. I move that the board approve the variance because all of the requirements of MCL 17.40.370 have been met. The board finds that the unique characteristics of the property are the existing and deep sewer line, and the precise nature of the hardship is the sewer line, the existing sewer line.
I'll second that.
We have a motion, we have a second. All in favor?
Aye.
All opposed? All right. Still passes, but anyway.
All right, that motion carries on a vote of 4-1. With that, the Board of Zoning Appeals is adjourned today. Thank you.